listening to Awake in Relationship, a podcast about intimacy, community, and culture in a time of great change, with Silas Rose.
Silas Rose, and you are tuned into Awake in Relationship. The recent killing of George Floyd in Minneapolis at the hands of police has sparked a global movement and brought to light the inherent racism and injustice at the heart of our institutions and body politic. Canada has its own history with racism, expressed uniquely in the relationship between the Crown and First Nations peoples. Sir John A. Macdonald, Canada's first Prime Minister, best summarized the colonial agenda in describing the purpose of residential schools as taking the Indian out of the child. Sometimes referred to as a cultural genocide, this colonial agenda and its legacy continues to this day, as the federal government attempts to deny First Nations of their inherent title and rights over the land. In this episode of Awake in Relationship, we discuss allyship with First Nations in the fight against eco-racism with Ana Simeon, a fundraiser and campaigner for Raven Trust, a not-for-profit that raises money to support First Nations in asserting their rights in the courts. Welcome, Ana. Thank you so much for joining Awake in Relationship.
Thank you for having me. Lovely to be here.
Perhaps we could start by talking a little bit about Raven Trust's mission and how it relates to this cultural moment that we're in, where there seems to be more willingness to look at historic inequalities and racism within our institutions.
Mm-hmm. Raven has a very well-defined mission, which is to support Indigenous peoples who choose to go to the Canadian courts to enforce their rights, their title, and protect their lands. So Raven works as a bridging organization, if you will, within the colonial Canadian system, assisting and supporting nations who choose to use that system to improve conditions in their community. We are, of course, cognizant and respectful of the fact that some nations do not choose to do that. They choose other avenues. They assert their sovereignty. And we wish them all the best. But what our small piece of the big puzzle is specifically about using the courts.
How did you first get involved with Raven's Trust, and what drew you to this work?
So I'm now 55, and this has been a very long journey that I couldn't have predicted. In my 20s, things were already happening that would eventually bring me here. And one of the things that happened was the war in my birth country, in Croatia. And while I didn't lose anybody in that war, I was a journalist. I saw the front lines. I felt there were many feelings, let's put it that way. And after the war ended, I worked for a long time with the War Crimes Tribunal. There were many, many war crimes committed by the various factions of the military in that conflict. And that kind of set me on this search for reconciliation and for truth and for justice. And when I moved to Canada in 2003, I knew I wanted very strongly to work on the relationship between humans and nature. And I ended up working at the Sierra Club of British Columbia for 11 years. And part of my work was campaigning for the end to the Site C Dam in northeastern British Columbia. And while working to stop this dam, I met and became friends with people who live in the region, and some of them were First Nations from West Moberly and Prophet River and Soto First Nations at the time. And that opened my eyes to the structural racism, the structural injustice that exists in this country, and in a way that was really personal, that was really heartfelt, because I wasn't reading about it. I was actually seeing and witnessing it, and seeing with what great courage and great heart members of those communities were working to achieve justice for their people, to protect the land. That deep relationship between people and the land was something that I think changed my life. And so when a position opened at Raven, it felt like this was my dream job and this is where I was meant to be. And I still am, and that's still the work that I do and probably will be doing as long as I live.
You know, colonialism in Canada goes back a long time, and in North America, at least 500 years. And often that history is sanitized, or I know when I was going through school, I didn't hear much about residential schools or the 60s scoop. Maybe in brief, could you just say a little bit about the history of Canada that doesn't really get a lot of airtime?
Yeah, so when I was visiting the Secwepemc Nation in the Thompson area in Kamloops, they're a nation that Raven works with on their title case. And they showed me the memorial they wrote to Sir Wilfrid Laurier in 1910, the then Prime Minister of Canada. And they were painting a contrast between what they called the real white people and the bad white people. And the real white people, in their mind, were the fur traders, the first fur traders that they encountered, who came into Secwepemc lands to trade. And because there weren't that many, not that they were particularly good, but because there weren't that many of them, and they were at the western end of the fur trade, they behaved respectfully, and the balance of power was more equitable, and the Secwepemc felt that the trading relationship benefited them as well as the fur traders themselves. And then when colonization became a project of the modern state in the latter part of the 19th century and especially in the first part of the 20th century, the imbalance of power, the oppression and the racism became structurally embedded. They hardened and became ways to do business across the board, across the country. I'm really simplifying this, but that's how that process solidified and then was encoded in the Indian Act of 1867. So when the Secwepemc were writing that memorial to Sir Wilfrid Laurier, they were pointing out that the new whites, the bad whites, were coming and taking their land. They were interfering with cultural practices. They were interfering with Secwepemc women, and all of the stuff that we are still dealing with, the marginalization and violence against Indigenous women, the taking of land, the polluting of land, all of that was happening as a state project. And from then, it has been a very hard struggle to overcome that original sin, if you will, of the Canadian state.
Mm-hmm. Yeah, perhaps we could talk a little bit more about the Indian Act, because it's sort of a central tool in that dispossession of First Nations from the land. What is it, and why does it still exist?
Mm-hmm. Well, this is a really good question, and the answer might surprise you as far as the why does it still exist. In terms of what it is, so it's a federal document that was first enacted in 1867, and that set the relationship between Canada and Indigenous peoples in a really paternalistic way, whereby Indigenous people were treated as children, as wards of the state. And Canada was given a lot of room for interference in personal affairs of Indigenous communities. At subsequent dates, especially in the early part of the 20th century, other provisions were added that weren't there in the beginning. For example, Indigenous people were prohibited from hiring lawyers and seeking their rights in court, which is something that Raven really remembers because we wouldn't have been able to exist back then. So all the court victories that we're now seeing would never have been possible under that version of the Indian Act. The Indian Act prohibited potlatch ceremonies, which as many people have now learned through the Wet'suwet'en struggle, that potlatch is a part of Indigenous governance for those nations, that it's part of how they govern themselves, how they pass teachings, how chiefs are chosen and anointed. So the explicit purpose of all of this was to assimilate First Nations, oppress them, and then assimilate them into wider Canadian society. And then, of course, the residential school system, which saw some of the worst abuses historically in this country against any ethnic group. So, your other question, why would it still exist? And the answer is really interesting, because we actually have seen an attempt by the Canadian government under Mr. Trudeau the Elder to do away with the Indian Act. It was called a white paper, symbolically, although white paper is used as just a name for a government document. But in this case, it really fit. It was a white paper. The idea was to do away with the Indian Act, with Indian status, with reserves, and quote unquote enfranchise Indigenous people so that they would have the same rights as every other Canadian. And that sounds really good until you reflect that that would have meant that any Anglo-Saxon Canadian, any Sikh, any Italian has the same status as First Nations. And something was not right about that. And First Nations strongly opposed this drive. And indeed, it resulted in a whole explosion of resistance throughout the country, which culminated with the so-called Constitution Express, when the Constitution was being repatriated. About 1,000 Indigenous people boarded a train to Ottawa and showed up to protest the loss of their special status and special relationship with Canada by virtue of them having been here since time immemorial and occupying the land when Canada came into being. So that cannot just be erased by the stroke of a pen. So the Constitution Express, there was even a delegation that went to the United Kingdom because, of course, the Constitution was being repatriated into Canada from the UK, which is the original colonizer. That was the UK Empire project that launched this whole expansion. So for Canada, of course, having our own constitution as a country was important, but it couldn't come at the expense of Indigenous people whose status and whose title was actually affirmed by the British Crown in the Royal Proclamation of 1700. I don't remember the year now, when the first Britons arrived in Canada. The Crown had said that Indigenous people had titles. So they had a relationship actually with the British Crown. And then once the British Crown devolved that to the Canadian government, and Canada was becoming not a colony, but its own country, it was only right that Indigenous people shouldn't lose that their relationship to the land and that status. And it ended up being a victory when the Constitution indeed affirmed, the Constitution Act of 1982 affirmed the existence of Indigenous title, Indigenous rights, treaty rights as a constitutionally protected legal fact.
Much of BC and Canada is unceded, which means no treaty. I'm just kind of wondering how this, in essence, from the state's perspective, in the inconvenient truth, has kind of set us up for many of the conflicts we see between First Nations in Canada now and, some of the major kind of industrial projects, including Trans Mountain Pipeline and, the blockades in support of the Wet'suwet'en and Coastal GasLink and stuff. So I'm wondering if you could talk a little bit about that.
Yes, the majority of the territory in British Columbia is unceded. That means there were never any treaties, except for a small portion in northeastern BC, which is under Treaty 8, one of the number of treaties, as well as there was a Douglas Treaty, historical Douglas Treaty on Vancouver Island. And then there is the modern treaty process, which many nations are criticizing as being a neo-colonial one. So there aren't that many nations who have signed modern day treaties. So a lot of the province is unceded. And I would say, yes, we see the conflict more overtly here because those nations have still kept, even through the Indian Act oppression, they have still kept their governance, their traditions, their languages, their alive cultures, and they're being revitalized and empowered as we speak. So, of course, they're going to be asserting their rights, even if those rights haven't yet been proven in Canadian courts. And that's kind of the catch-22 of the Constitution, which gave these, or not gave, but recognized these rights in principle, but didn't create a process for enforcing them. So the only process the nations have within the toolbox of the Canadian state is to go to court, which is so expensive, and which is where Raven comes in. But many nations don't have. Raven can only help a few nations. So there is all of these land claims and land title that theoretically exists, but in the meantime, the province doesn't care because it hasn't been proved in court. So that's a source of conflict. But if we look at the treaty lands, the same conflict exists. There is treaty rights that are actually enshrined in treaties, and the provinces and the federal government both are violating or more insidiously just interpreting very narrowly those treaty rights. So there is cases happening in court on that side too, with the difference that with the unceded territories and the unceded nations, it's somehow maybe even perceived to be easier and more, there is a potential and an opportunity there, since those lands are unceded, to create a relationship anew now, compared to the historic treaties where so much of the dispossession has already become a fact.
So what is usually the result or outcome with First Nations when these battles do make it into the courts?
Well, it varies. We have seen in our 10 years of existence as an organization, we have seen an impressive slew of legal victories, both on title and on unceded land. One of the key ones on unceded land, which Raven wasn't involved in, is the Chilcotin title action, where they have one title and are now self-governing their land and building their economic activities according to Indigenous principles and to benefit their community. In terms of Raven's involvement, we've seen pipelines stopped, like Enbridge. The Trans Mountain is still being fought in court. We've seen mines stopped. Again, the Chilcotin Territory, the Taseko mine, the Supreme Court just affirmed the Chilcotin victory, and Taseko will not be able to come back with more mining because they have exhausted all the legal remedies that were available to them. So the New Prosperity mine is done for good. And on the treaty side, we've seen the Peel umbrella agreement in the Yukon that protects the entire Peel watershed from mining and oil and gas development. And that was also a very long and arduous court battle fought by three Yukon nations, Trondakwachin, Wontut Gwitchin, and Nachanyak Dun, alongside Canadian Parks and Wilderness Society. And it's an amazing treaty victory that resulted in a modern day treaty that actually protects this land and enshrines a lot of First Nations decision making in the process as well.
What is the difference between Crown law and Indigenous law? And can the two coexist? They seem like very different worldviews.
So the Crown law is actually, Canada already has in its makeup two very different colonial legal systems, which is the common law of the Anglo-Saxon speaking peoples and the civil law of the French speaking people in Quebec. They're a very different system, and Canada includes both of them. And so some Indigenous legal scholars are now saying, for example, John Burrows, who is a professor at the University of Victoria, amongst many other honors, he's actually saying that Canada is and should have a third leg to that stool, and that is Indigenous law, that whenever possible, Canada should incorporate, and indeed in some ways does incorporate, Indigenous law. Indigenous law is law that was developed by Indigenous people themselves over the centuries and millennia of their existence on this land. So they're an autochthonous legal system, or legal systems. They're different for each community or each nation. And in some ways, some of those things are being implemented, for example, in the criminal justice system, in Indigenous communities, but there could be much more done, especially on the environmental side, and protecting water, for example, and the status of water and land and animals as entities that we as human beings have a relationship with and have a responsibility to, versus dead objects that we manipulate and profit from. So there is a huge potential there, and there are organizations like West Coast Environmental Law that are working with Indigenous communities to develop model legislation and policies that would effect this melding of the two or three legal systems.
So we've covered a lot of ground so far in this conversation, and a lot of that's been kind of identified in the Truth and Reconciliation Commission's 94 action steps. And I'm kind of wondering what you feel are some of the most important things to kind of get working on right now in terms of the TRC recommendations.
Well, they're all important, but there is a really easy one that Canada nevertheless keeps avoiding, and that is to publicly repudiate concepts like the doctrine of discovery and terra nullius that are used to justify European sovereignty and land grab. And it may seem as a declaratory step, but it actually isn't. And we've seen that with Jody Wilson-Raybould when she was Attorney General. One of the last things she was able to do before she was removed from that function is that she gave an instruction to Crown attorneys who are opposing First Nations in court in various different ways on various different cases to stop arguing that First Nations don't exist, that title doesn't exist, and start from a place of actually accepting what the various Supreme Court judgments have said, what the Constitution says, so that they're not every time starting from zero and making the nations argue about their own existence. And so actually publicly repudiating the doctrine of discovery and making that step that Canada is now not going to oppose nations on those basic principles would make a huge difference in all of these cases that Raven works with, that nations are fighting, because it would make a difference of millions of dollars in wasted time and money fighting things that the Crown knows are not going to fly in court. The only reason they're doing that is to try and outspend the nations, try to delay, and try to just make the case go away by attrition. And that's a really underhanded, disingenuous, and shameful thing to do. So this simple step of just acknowledging, yes, you exist, yes, there is underlying title, let's see how we can work together on the details. And you might have to be opposed on details, and modern society is complex and there will always be court cases and conflicts, but we shouldn't be arguing whether a nation exists.
Yeah, it's a not so subtle form of racism for sure.
Yes. And I would mention just one other one that I personally find really poignant, although it doesn't have anything to do with land. It's called Jordan's Principle. That's one of the calls to action from the Truth and Reconciliation Commission to finally implement Jordan's principle. And that comes from the tragedy that befell a young boy, 5-year-old, who died in hospital at 5. And he had a life-threatening condition, and he would have died anyway. But the reason why he died in hospital and not at home, he never saw his home after his birth. And the reason why was because the province of Manitoba and the federal government kept fighting who was going to pay for his care. So Jordan Principle says that First Nations health, especially child welfare, have to be fully funded, and decisions have to be made for the welfare of the child, regardless of any kind of funding questions and problems. To me, short of having somebody's knee on your neck, withholding care from a child, a sick child, just because that child is a First Nations child, is the worst possible form of racism that can exist. So I encourage everyone to read the calls to action. They're mostly aimed at the governments. There is a few of them that are aimed at churches, which also participated in this cultural genocide of residential schools, but most of them, the majority, is aimed at governments. And inform yourself what they are, and see how your particular provincial government is working on it or not working on it. And of course, we are all responsible for what the federal government does, and we should hold them to account.
I think, we're kind of living in a time when there's a lot of awareness and awakening around these issues with our colonial past, and certainly with Black Lives Matter in terms of racial inequality. And I think for settlers, people that are not Indigenous to this land, when we're learning about this history, our first feelings are really about guilt and shame, which doesn't necessarily lead to action. I'm wondering what you feel the role of non-Indigenous people is in terms of supporting Indigenous rights and title.
Yeah, those feelings do come up. I've witnessed them. I witnessed situations where they came up in a mixed group where there were First Nations and non-First Nations, and this white woman, it was in the Okanagan, and the discussion was about water rights and how the Water Act has actually dispossessed First Nations and reserves out of their own water because farmers and agricultural interests and even mining interests sometimes have first access to scarce water resources. And so a First Nations woman was explaining this issue of water in a really profoundly felt way. And then the white woman who was there started crying and burst into tears and said how responsible and how ashamed she felt. And then the First Nations woman said, well, it's not your fault personally. Don't put that on yourself, because then I have to, and I'm paraphrasing, that was a few years ago, then I have to deal with your emotion. And that's the point. None of us have created this system, but we do need to look at how we are complicit with it, how we participate in it, how we enable it by our silence, and what other choices we can make. Because we can very easily make a choice once we are aware. We can make a choice to be in solidarity. And that can be a really beautiful journey that we take together. And sometimes an emotional journey, but it's absolutely worthwhile. And we've seen, Black Lives Matter protests, so many people were carrying this sign, silence kills, and it does. Mm-hmm. So I think the first thing we can do is to, yes, be silent in the sense of listening when Indigenous people are speaking, but then also use our voice, our privilege that we still have as white people, work to dismantle it, but use it when we can use it for good, use it with government, use it if we witness a racist incident, and use our agency and our voice as human beings to make a different world.
Education is a big part of social change, and rewriting some of the historic injustices and inequalities built into our systems. I'm wondering how people can find out more about reconciliation, some of the issues we've been talking about.
Well, there is so many resources, and I won't even get into social media. I understand there is a lot on Instagram these days, including teaching videos and stuff like that. So if you're in Instagram, you might search and find some things like that. I'm 55, so I will allow myself to, start with what I started with, which is books. There is a wonderful Indigenous elder and teacher named Arthur Manuel, who unfortunately passed away in 2017. We lost him, but I always think of him as the Canadian Mandela because he has such an incisive clarity of vision and also a very big heart that encompasses everyone. So it's a very unitive approach, but also a very trenchantly justice-based approach. So the book that I would recommend is Unsettling Canada, and that will give a bit of a historical overview of the oppression and resistance. We must never forget the resistance piece. It's not that First Nations were just victims. They actively resisted and continue to resist. The book will also talk about the present-day system, the injustice of the reserve system and band council, imposed band council governments under the Indian Act, and we'll have a lot of resources at the end. There is also the organization in BC, the Union of BC Indian Chiefs, that has a lot of resources. They have an email list and the group called Coast Protectors that's in particular focused on stopping the Trans Mountain pipeline. And so many other places to go. Raven itself also has some resources specific to the legal issues we deal with, including a PDF called Understanding Rights, which details all the legal trajectory of winning recognition of Indigenous rights.
That's great. Well, I'll put those. I'll put some links in the show notes to this episode, so people can kind of click through and get in contact with those resources. So, Anna, I just want to say thank you so much. It's been a really important conversation, especially with what's going on in our world right now, and I hope at some point we can talk again.
You're very welcome. It was a pleasure.
Thank you again to Anna for this informative conversation. And if you want to learn more about Raven Trust, head on over to raventrust.com. I will also post some links in the show notes, so you can go to awakenrelationship.com for that. I really appreciate you tuning in, and I welcome your feedback, so you can send me an email through the website or reach out on the socials. And don't forget to hit subscribe. Until next time, stay connected.
Thanks for tuning in to this episode of Awake in Relationship. If you liked what you heard, please click subscribe to get the latest show delivered fresh to your device, or sign up for our newsletter at awakeinrelationship.com. Sharing is caring.